at a wedding in South Florida in May. And when we were sitting at the pool the day before the wedding, a number of the out-of-town guests, someone asked me what I did. So I told them, we had a nice conversation. The next day, she presents me with the front page of the Miami Herald, which has a story and lists 15 or more hospitals in South Florida where every single hospital had a cesarean section rate of greater than 50%. Now again, this is practice style driven primarily, not hospital administrators driven. Sure, if VBAC is limited, that may have an impact on the cesarean section rate, but the majority of cesareans are primary cesareans. Now, I would look at that, and quite frankly, I'm appalled. I find it amazingly hard to justify how anywhere in this country we can have a 50% cesarean section rate. There is no way I could look at myself in the mirror and think that I was doing the right thing as a healthcare provider because of some of the morbidities that we've talked about today. But on the other hand, as appalled as I might be, I think there's some reason to understand this, although we might not all want to accept it so strongly. But look at what OBGYNs pay for malpractice. In Miami Beach, $275,000 for yearly malpractice. So we may not like the cesarean section rate, but we cannot get away from the fact that in 5 of these 6 studies, 5 of these 6 cities, the malpractice rates are astronomical. My wife, by the way, happens to be a medical malpractice defense attorney. If her lawyers paid in her firm in aggregate what one obstetrician pays for in Illinois, they'd probably go out of business. I mean, it's just something that we have to deal with, and we have to acknowledge that it does influence practice. Now, these are some data from the state of Illinois. And we in Chicago are in Cook County. These are actually somewhat encouraging. If we look at new suit filings in Cook County, which is the magenta, and the state, which is the whatever color that is, you can see they were tending to go down. But unfortunately, last month, something very bad happened in Illinois. Our Supreme Court decided that the tort reform that had been enacted in Illinois was unconstitutional. So what we're going to see, I don't know. This was somewhat, I want to say exciting, but hopeful, but whether that continues will remain to be seen. These are sobering data that are certainly well known to all of us. And these data look at Cook County, and they look at all med-mal cases, neurologically impaired babies, looking at the average indemnity or the average payout for a bad baby case. And you can see in Illinois, $8 million in 2005, $10 million in 2004. So quite a significant concern on behalf, I think, of all healthcare providers and all administrators. Now, these are data that were compiled for me by our risk management office at Northwestern, looking at the historical claim volume by department from 1996 to the present. And I'd like to just take you through this. I think it's actually sort of easy to understand if I just help. What we have on the bottom here are different departments at Northwestern. What we have here is a cumulative claim volume once we start adding these departments together. So over here, we have surgery. 35% of the claims against Northwestern Hospital in this time frame were in the Department of Surgery. Medicine accounted for another 22%, so by the time we get to here, then 57% of the claims against Northwestern are surgery and medicine. We had OBGYN, it's another 18%, so we see 75% of the claims against Northwestern come from those 3 departments. By the time we get down to something like dermatology, 1% or less. But we see then 18% of the claims against Northwestern Memorial Hospital come from the field of obstetrics and gynecology. Of course, mostly obstetrics. But if we look at the payouts, 60% of the payouts over that same time frame came from our department. The other departments are going to contribute much less significantly. So what does all this mean in my mind? I don't think there's any doubt that often, probably too often, medical decision making and practice style is influenced by the medical legal climate we work in. I think that's really, really unfortunate that we're in that state. Will tort reform change things? I don't know. I think we can say for pretty certain, though, that in the absence of tort reform, we are going to have the hardest time reversing the trend that we have seen. And since I have the podium, I'll really go on a limb and say one thing which may or may not be very popular. But if tomorrow every one of these VBAC patients signed a consent that was binding, which has been a problem in the past, and that consent simply said, I accept the risks that are assigned to me, and I promise not to sue if I have any of these adverse complications. If that happened, was binding, could be enacted, we wouldn't even have this conference. And so there is no way we can deal with this problem without addressing the medical legal liability issues that both physicians